Welcome to the Fox Robbins Business Show. Welcome back. Come on in. We've been doing this show for since 2008.
Right after the Civil War.
Right after the Civil War.
Post-Bellum.
So we got a lot of episodes under our belt. This Fox Robbins Business Show is all about creating or helping and abetting your very best business ideas. And we're cheerleaders for small business, and we want small business to succeed in every way. And these episodes are supposed to be helpful, that we're using the TV medium to get ideas across. There's plenty of books. You can go to the library, and there are 200 shelves, covered with business books. But which one do I read is the question.
I've read them all. Here
you can look on our, we have a library on YouTube, and you can look up the topic that of interest and look at it anytime you please. I'm Bill Fox, the co-host, but the other co-host. Now get this guy is torrid. He's portentous and provocative. He is Coach Robbins.
Mr. Bill, how are you?
Coach.
Most of the words he uses to describe me, I don't even understand.
We got it's kind of extra special. We got a couple episodes with Doug Denninger, and Doug is an attorney. So don't be scared. Don't turn the TV off. It's okay. We're going to cover. Doug is going to help us out and talk about all different types of protection for intellectual property, and we're going to get into that. And Doug, nice to have you on the show.
Pleasure, Bill. Thanks for having me.
Been a long time. I've had your name on my list for a long time.
You're persistent.
And this may not be the last time. We may have to get you back.
Look forward to it.
You can blame me because I kept him on you. You got to get a hold of Doug. You got to get a hold of Doug. So sorry, Doug.
There's also the disclaimer part. We have an attorney on, and we've done this, previously. But the show, this show will contain only generalized, legal information. It's not intended as legal advice or a complete discussion of legal issues related to entrepreneurs or other business. Okay.
I tell my clients all the time, I can give you a little legal advice, but I'm not an attorney. I'm not that smart. So you really should see an attorney if you want the right answer.
So, Doug, we're going to jump right into it. Into your introduction, and practical ideas, appearance, writings, artwork, names. Tell us, start from the top. Practical ideas, what's on your mind there?
Right, well, it's a question of what do you use to protect. IP, intellectual property, are like tools. So what, did you grab the hammer or did you grab the saw? Right. Practical ideas, meaning how things work. And that's generally going to be a patent, a utility patent. And that covers the underlying, either the composition, what it's made of, or how it's put together, or the method of using it. So kind of the concepts that underlie something. That would be for utility patents. Or trade secrets, but we'll talk about that in the end.
All right, okay. What about appearance?
That would be the way something looks. And that if you want to cover the overall shape and it's got some benefit, this pen is shaped a certain way, and other pens are differently, you can get a design patent that covers that ornamental appearance. Right. Doesn't cover what's inside, just covers the shell and what it looks like. Right. That's right.
Okay. Then there would be writings and artwork.
And that's generally copyright. So you take that pen, you got a utility patent for how it works, you got a design patent for the shape, and you start writing something, and that work, it can be the subject of copyright. And copyright is very broad. It can cover, art, writings, and as we'll get into, it's one of the cheapest and most powerful forms of protection.
We'll get into where you do these things, right?
That's right.
Okay.
And finally, you've listed names and logos.
That's right, and that's going to be, what do you call this thing? And that would be trademarks. And that would be how you identify your product to your customers.
Coca-Cola.
Coca-Cola, right. That's right.
Nike swoosh.
That's right.
Okay, and also part of your introduction, there's an important component is where.
That's right.
What did you mean by that?
It's a question of, are you applying to the state that you're in, the Commonwealth of Massachusetts or Rhode Island, New Hampshire, and typically for trade secrets and contracts, that's a matter of state law. Trademarks can be a matter of state law, or it can be federal. The U.S. Patent and Trademark Office protects both patents and trademarks on a nationwide basis. So rather than having to apply to all 50 states, you can do it in one place and get protection throughout the United States.
So if you want to trademark something, let's say in the state of Massachusetts, that doesn't mean you're protected in Maine or Wyoming, right?
With a state trademark, that's correct.
Right.
In order
But if you want to protect it nationwide, you go to uspto.gov, is it?
That's right.
And it's a little more money, obviously.
A bit, but
Yeah.
not much more. But again, the value is so high because you
Yeah.
get so much more
50
protection.
states. Right.
Right. But on the other hand, it is just within the United States, and that
Yeah.
gets into country by country. That if you want,
Asia.
that's right. That's right. So to get the regions like Europe or individual countries, you need to make separate applications.
Right.
Okay, so also on the staying on the topic of where, there's you listed county or region. What did you mean by that?
Well, country or region actually, and
country.
and that's fine. That gets into you can apply to the country, the United Kingdom, to Germany, to France, or you can, in some cases, get regional protection. All of Europe, parts of Asia, Eurasia, there are different regional protection frameworks as well. So this whole session today is going to be about spotting issues and understanding what you might have, and then you talk to an expert about what to do with it.
Okay. Then you listed when and how.
Right.
What was your idea on that?
Well, one of the challenges for small businesses and many others is that you have a budget and you need to stagger your expenditures. On the other hand, you need to make sure that you act early enough not to lose rights. And so that when becomes important, because in most countries, you need to have a patent application filed before you make something public. So you give a presentation, you make some, put it on the web, and now you've lost
Public knowledge.
It's public knowledge. You've lost most abilities to go internationally.
Right.
The U.S. still has a 1-year grace period, so you have a year from when you make it public to proceed for protection.
To file for
That's
a patent, right.
That's right. So there's all these 6-month, 12-month, and as soon as you get into either the appearance of the design patent or how it works with the utility patent, you need to know that the clock's running. In many cases, you need to act sooner rather than later.
Right. First time you sell your beta product or just show it to the public or show it to a VC or an angel group, you got 1 year to get that patent
That starts for 1 year in the U.S. You may have lost international. You can still present it under confidentiality, and that gets into the NDA.
Getting an
non-disclosure
NDA
agreement.
from a particular angel group.
That's
They
right.
don't like signing them anyway.
Exactly, which is why you're better off having the application
That's
filed
right.
first.
That's right.
It's just one thing, Doug is being polite about it, but it's to say that you have a secret of patents order, loose lips sink ships. So button your lip and be careful if you've got special ideas that need protection. Be cautious.
Talk to your lawyer first.
Talk to your attorney first.
So I tell them, you got to say
right.
lawyer, I tell them.
Yeah, and the last part here is the who.
Yeah, the who. What do you have there?
That gets into who has come up with this. The person that writes the article is an author.
Right.
The three of us collaborate, maybe the three of us are authors.
Right.
We'll get into inventions, and it gets into who contributed to the conception. And if the three of us are inventors, all three of us have separate ownership rights. So if you license someone with the invention that the three of us have come up with, that's great. You've given them some rights, but it's not exclusive because it didn't include rights from billing
my two
me.
partners who are on that patent.
Right. So you always want to see who's involved, and it's usually narrower than the whole team. It's actually who was in the creation of the copyrighted work,
And who's listed on the copyright or the trademark.
and that gets into who's properly listed or not.
Right.
That's right. So And for employees, if you're an employer, you want to make sure you have a good employment agreement that makes sure that anything that's done within the scope of the employment is owned by the employer.
The company, like a university that's doing research, MIT and UI, they're doing research.
That's right.
Well, they're being paid by MIT to do that. Therefore, MIT has the right to it, so to speak. Now you can work with them, you know, and pay them a royalty or whatever as you commercialize the product. But you got to pay attention to who paid you to figure that new thing out, right?
That's right.
Yeah.
Who did it and who paid for it?
Exactly.
Okay. So let's jump into the meat of your ideas and presentation and start with utility patents, structure, composition, methods.
Sure. So that gets into utility patents. When you hear patent, that's usually a utility patent that covers how things work, and the composition's what it's made of. It can be a formulation, it can be whatever you've done that's new, that both novel and not obvious or not readily apparent to people in your field. So you need to make sure that you're working you understand what you've come up with and then see how you can protect it. So that gets into, for patents, it has to be both new or novel and sufficiently different or not obvious from others. You know, you get the doorknob and it's brass, you make it out of stainless steel, that's probably not enough of a difference to be patentable.
Right.
But now it operates in different ways, it's got a special lock. That lock could be the subject of a patent protection.
Instead of twisting it, you pull it and flip it.
No doubt about
maybe
back
that's
when we went from key, you know, the key lock to the push button or you know, electronic stuff like that would be novel.
Absolutely, and then there's the card, the magnetic card has the code that you swipe. So those are all patentable improvements and inventions.
Fingerprint, you know.
That's right.
But novel. Remember that word. It's widely used. It's part of the lingo of the patenting process. Is something that's novel. So know that word and use it.
That's right. You have to be at least novel, but then you need to go a step beyond that to have some inventive step. But if you're not novel, then forget patenting.
All right.
And next is rights. That says exclude others. What's the idea there?
Each type of intellectual property has a different form of protection. It gets you different things. And what most people don't understand is that if you've got a trademark, you've got a patent, they think that's permission to use. You get a driver's license, you can drive your car.
Right.
But this is different. What a utility patent does is it gives you the ability, once that patent is granted, to exclude others, to prevent others from practicing your method or make your invention.
Your product, yeah.
That's right. But you stop others. But one of the reasons you don't automatically have a right to proceed is that there could be earlier patents. Suppose Bill has come up with something in 2008 when you guys started, and now I come up with something, and it may be some improvement that's patentable, but Bill could have a dominating earlier patent.
It's got an underlying patent that your patent's going to have to deal with you if you go to commercialization.
Right. So as an inventor, you want to know, geez, what I have patentable, and you look at what's been done before to see if you've got some inventive step. You're not obvious over what's done.
Right.
But then, as a practical matter, if you want to commercialize it, think about right to use, freedom to operate. Actually, look at the claims.
That's the important word I would need you to get to, is the claims, right? Yeah.
Utility patents can be quite long. They have figures and all this text, and it's all there as support for those numbered paragraphs at the end.
Right.
Those claims are what actually define the invention.
Right.
With real property, you've got your property boundaries. You got 100 feet north, and then you go west, and you can carve it out with those dimensions on the map. With intellectual property, it's conceptual. It's like three-dimensional chess, So you have to carve out what you have as compared to what others have done before. And those claims specify what it is that the patent office has said, yeah, we think that's both novel and not obvious.
Right.
You mentioned this earlier, is a file. You get a file. What before disclosure?
That's the timing aspect. if you want to protect your rights internationally, have the application prepared and filed before you talk to others about it.
Right.
Unless it's under an NDA, non-disclosure agreement.
Right. In the United States, you've got 1 year from the time that you either put it on your website, begin talking about it, and that 1 year clock starts ticking, and you better file that patent before the year's up, because then it becomes public knowledge again, correct?
That's right. And timing is important, not only for when do you first file this, but then when do you decide whether you want to expand your protection? Do you want to go into Europe or elsewhere? And
Right.
you know, you've got your filing date, then you've got another 12 months for a utility patent to decide what international protection you want. So, you know, there's all these time bars, you know, clocks are running. With design patents, we'll get to, you only have 6 months. So, you know, this 1 year is a good starting point, but some things are sooner.
Right.
And your next item on utility patents, identify.
That's, once you file the application, it's now patent pending. And it'll stay patent pending as long as that application is still alive with the
Right.
patent office and being looked at.
Right.
Now, you don't know what those claims will actually look like. And in fact, after 18 months from your earliest date, it'll be published. And you can have that application, patent application published with claims at the end and whatever, but you don't know what you're going to get. So if you see a published patent application, that's a starting point, but then you need a little further analysis to see just what protection they might ultimately get.
Right.
So it's all patent pending until it becomes an issued granted patent.
Right.
So further on utility patents, structure composition methods, we have search.
Right, and it's always good if you want to consider patenting something, do your homework. Google type searching is great. There's the general Google, there's also a Google Patents that focuses more on the patent databases.
Right.
You can try each of those. Patent examiners are using Google now
I think
to
it's so
put
good,
things
but the
together.
SQL, you know, you can put the right words in there. It's
Yeah.
amazing what you can find.
One of my clients had a raft with dried sponges, and it was an emergency raft. And if you are on a plane, you're on a kayak, you want that raft to be lightweight. And yet, once you need it, you want it to be quite stable. So these dried sponges would be in there, you put it in the water, the sponges would soak up water, and now it would add all this balancing weight. So it would make it a lot easier to get into the life raft.
Right.
The patent examiner did a Google search and found a 1934 blimp patent. You know, one of those dirigibles.
Yeah.
And there in the patent, they said, oh, and you can have a little sea anchor where you have a little mesh bag with sponges in it, and you throw it in the water, and it becomes an anchor.
Right.
And, you know,
You got to deal with it if you commercialize that raft.
So is the invention in the relevant field? Typically, you know, aeronautics is quite separate from maritime safety,
Right.
but in this case, there was enough of an overlap that it was a problem.
Even though it was over 20 years old?
Well, see, prior art lasts forever. It's
Yeah.
the disclosure
Okay,
of what
yeah,
others
no.
have done. That 20 years indicates when that patent no longer has teeth. 20 years after a patent has first been filed, you can't get protection on it.
Right.
So it expires. You know, the whole idea of a patent is it encourages people to make public their invention. You
Right.
write it up and describe it. You have to write it up in a way that's understandable and workable.
Right.
So people, after reading it, can actually make and use your invention.
Right.
And in exchange for doing that public service, if you will, you get a limited monopoly. You
Right.
get the right to exclude others for up to 20 years from your priority
For that
date.
specific one.
That's right.
Downloads, what's this about? Download www.pat2pdf.org.
That's right. I'm always interested in free things, and you can do more and more things without charge. And one of them is getting copies of patents.
Right.
So Google Patents will have many patents, but I like this pat2pdf.org because it just you're able to download the whole patent in a PDF file all at once. So it's another thing. You know, Google's free, pat2pdf is free, uspto.gov, the government website, no charge for that. So there's an awful lot of research and coming up to speed you can do, and at least get to the stage where you have a better idea of what's out there before you have a professional look at it.
Okay. And this EPO, Europe, what's that?
You may hear about EPO or EP patents. That's an organization that covers 27 countries within Europe. So kind of one-stop shopping for EPO, European Patent Organization. PCT, the next one, Patent Cooperation Treaty, is a way to preserve rights. And as I've mentioned, you got to act within 12 months of your filing date for international protection. But every country has their own charges. And it may take a couple years to see, is this something that's going to be commercially viable?
Right.
Is it going to be worth many thousands of dollars in each country to protect?
Right.
Well, the PCT is a placeholder. It's an international application that basically is an option to pursue in almost all countries in the world, with some exceptions. And that gives you up to 30 months from your earliest date. So that's 2.5 years before you really have to commit going elsewhere.
So you can do your research and say, maybe we can sell this in Germany and England, but probably not Spain, Portugal, and try to get yourself some idea. Am I going to make money if I spend all this money on the patents for Europe?
Yeah,
'cause
or
that's what it's
is
about.
Australia going to be important?
Exactly.
Or Japan or
Australia,
China?
Right.
And those are all covered under this PCT
Right.
As a placeholder for up to 30 months.
So Europe is Europe, obviously. Well, what about Australia, and what about China, Japan, North Korea? Are they all separate?
Generally, yes.
Yep.
They've got there's a few regional protections. EPO for Europe.
Yep.
There's a Gulf Cooperative for many of the Middle East. Eurasia for some countries, but almost all are step by step.
Yep.
You have to do country by country if you want to be protected.
Right.
Okay. Can we move on to design patents? Novel, ornamental appearance, words that apply to this. And start off, you said your rights. Start with your rights on design patents. What are your rights?
So just like a utility patent, you have the right to stop others from making, using, or selling whatever concept is covered in the claims. With a design patent, you cover really what it looks like.
Right.
So you change the shape, and the design patent no longer covers it.
Right.
But it's pretty good at stopping direct knockoffs. And one of the important things about patents, about design patents, is they can be used not only for the physical objects, they can be used for graphical user interfaces. They can be protecting some of the screen icons and such. So this is something that doesn't have to be physical, but if it has an appearance, a design patent may be a way to get protection on that new fancy icon you come up with.
And you want to file, again, before disclosure.
Ideally, you again have a year's grace period, and after you file a design patent, you have 6 months in which to pursue international. So rather than the 12 months for utility, you only have 6 months for design. That's why you always want to understand, what are the upcoming deadlines and due dates. And for design patents, you have to act within 6 months.
Okay. And identifying that, you identify that design patent.
That's right.
Patent
That's
pending.
right. So, strictly speaking, it's still patent pending, but more precisely, it's design patent pending or design patent pending.
Are you legally obliged to do that? I mean, you're to notify the public. I mean, there's a law or regulation or something tell you that you have to, instead of saying patent pending, you have to say design patent pending. Do you have to say that?
Well, it's a great question. Do you need to say you've got something pending? And there are advantages to doing. The short answer is generally no, you're not required. But if you want to get monetary damages from when your patent is published and even after it's granted, you want to make sure that you've marked it.
And you told them, look out.
Yeah, so patent pending while it's pending. Once it's issued, then make sure you put the the patent number on the product.
Right.
And one recent change that's nice is you can actually, rather than putting all the patent numbers on your product, you can actually, on your website, just have a page, a legal page, where you list your patents on the website. So, on packaging, say, see foxrobbins.org for our list of patents.
Right.
And that way you can keep it up to date online and with the latest and greatest of your activities.
I don't know if I should bring up a controversial question or not,
Sure.
but what the heck, why not? Does China care?
Protection in some countries is challenging. And
That's a nice way to put it.
Yeah, it can be done.
Yeah.
And so if you've got business, especially if you have an office or people you can work with in China to
Yeah.
help enforce it, then yeah, it's worth going for.
Okay.
This gets into the whole cost benefit, is it worth it?
Yeah.
And the good thing is that even if it's made elsewhere, a US patent allows you to stop things at the border. It not only stops making, using, or selling, it stops the import. So you can work with the International Trade Commission and get them to stop
Even though you've
the
only
import.
filed in the United States,
That's
it
right.
technically stops Chinese manufacturers from shipping your product into the country.
That's right.
But they do it.
Yeah.
They're breaking the law.
Yeah, but again, you can stop them by asserting claims. Litigation's expensive.
Yeah.
Cheaper and faster is going with the ITC, the International Trade Commission. So
Right.
there are ways
Okay.
to stop them on the border.
Okay, because I've seen Ping Golf Club, my pro showed me Ping Golf Club, and at the quick glance, they looked identical.
Yeah.
The swing weights weren't right, the quality, but they copied the design of the logo, everything.
Yeah.
They're breaking the law. Somebody's over there
That's-
shipping Ping drivers in,
Multiple infringements, and if they see that and they see who's shipping it in, you can be stopped at the border.
and they can go find them, yeah. Okay.
You have a note here.
We'll skip that.
You want to skip that one?
Yeah.
Okay, good. Well, we're gonna end this episode, but we're gonna pick up a second episode to talk to you about this protection of intellectual property. We've been talking with Doug Denninger. This is pretty special. We've been wanting him around for a long time.
Oh, yeah.
But anyway,
We hounded them. I mean, we just chased
so
this
many people wishing to start a business, especially with a new idea, need to know the information that Doug is giving us, but even established companies also, of course. Thank you for watching Fox Robbins. We do upload the shows to YouTube, so be on the lookout. Go to YouTube, just type in one single word, Fox Robbins, FOXROBBINS, and click into the library for the shows and watch when it's convenient for you. And we'll see you guys next time.